afternoon, everyone. Welcome to our next webinar in the Public Safety Innovation Series. Thank you all for joining us today. My name is Ari Vidali. I'm the founder and CEO of Envisage Technologies, and I will be your host today. Just a couple of housekeeping notes before I introduce our speaker and this incredibly important topic. First, the webinar today is going to run just about an hour, with approximately 40 minutes of presentation and 20 minutes for a speaker to take your questions. So at any time during the webinar, please feel free to enter questions into the chat box in the lower left-hand corner of your screen. I hope you all can see that. Also, we will be recording today's webinar, so you'll be able to share this valuable information with others in your organization. We will be following up after this meeting with details about how you can access the recorded webinar. Okay, so let's get started. Envisage Technologies creates technology solutions designed specifically for law enforcement and public safety. We started this webinar series because we are passionate about amplifying good ideas and best practices for our law enforcement and public safety communities. We fundamentally believe that readiness does save lives, and we're committed to improving the public safety world through innovation. Today's webinar is no exception, and if I see how many people have signed up for this, it's quite a popular topic. Litigation against law enforcement corrections officers is accelerating. I was just on the phone the other day with the former CIO of a state corrections organization. He told me that during any given day, there were 10,000, that's 10,000 open litigations against their department. Aside from the immense expense this represents, there can be serious repercussions for officers and their supervisors if we are unable to prove in a court of law that we are in compliance with applicable statutes, are trained in conformity to our policies, and can document this training in a legally defensible way. Beyond the value of mitigating litigation risk, providing legally defensible training also ensures that the training is qualitative, relevant, and meets the requirements of the job. Doing this right means combining great training with legally defensible records. This is the only way that officers are best prepared to perform in dangerous and difficult situations and return home safely. And departments are best prepared to defend themselves in the event of any litigation. Now, our speaker today is dedicated to understanding the intricacies of what makes training records not only admissible, but ironclad in a court of law. We are really fortunate to have with us today Gerry Roberts, JD. Gerry is legal counsel for Envisage Technologies and member of the Indiana State Bar Association. He has worked at the Indiana Office of the Attorney General, the Denton County District Attorney Office in Texas, and the Dallas Public Defender's Office. Gerry has also served as an administrative law judge. He's published several articles and white papers regarding training standards, minimizing litigation costs, and creating legally defensible records for public safety professionals. Gerry, it's a real pleasure to have you today. I'm going to turn this webinar now over to you.
Thank you, Ari. And good afternoon, ladies and gentlemen, to most of you, and good morning to those of you on the West Coast, and thank you for joining me. I'm here today to discuss a topic which is often overlooked by law enforcement and corrections organizations, but seldom overlooked by the plaintiffs that are suing you: how to make training legally defensible. As Ari mentioned, at any given moment in time, there are tens of thousands of pending court cases against public safety professionals and agencies. And perhaps the only thing that they have in common is that at some point during the litigation process, someone is going to ask about training. And the way you answer that question can either make or break your case. As Ari mentioned, I've worked for public defenders, a prosecutor, and an attorney general before taking my current role at a company whose mission is public safety readiness, Envisage Technologies. In addition to being legal counsel for them, though, I am an expert-level chess player, having played for a national championship team in college. Based on these experiences, as disparate as they seem, I've come to realize that there is a common denominator that is key to success both on the chessboard and in the courtroom, and that is anticipating your opponent's moves. So if you walk away with nothing else from today's discussion, it is this: To overcome your opponent, you must become your opponent. And that's from Sun Tzu's The Art of War. And as you can see, this is hardly a new concept, but one which resonates as strongly today as it did 2,500 years ago. As law enforcement and corrections professionals, you use this concept already in a variety of ways. Undercover cops and inmates, predictive policing models, but you may not be doing it to prepare yourselves for litigation. So you may be asking, who's the opponent in today's scenario? Is it the inmate that brings a lawsuit for negligent medical treatment? No. Is it the civilian who files a suit for excessive use of force after being arrested? Not today. Who then? Well, for one, I am the enemy. Well, not me per se, but certainly my kind, lawyers. I'm going to leave the lawyer jokes to you guys, but suffice it to say that our reputation is not entirely undeserved. Well, maybe I could do just a couple to illustrate my point. What's the difference between a lawyer and a boxing referee? A boxing referee doesn't get paid more for a longer fight. One more. What's the difference between a lawyer and a herd of buffalo? The lawyer charges more. In all seriousness, though, lawyers can make things very difficult, very expensive, and very time-consuming for departments when something goes wrong. That is, unless you're prepared for them. To successfully defend your department from expensive lawsuits and judgments, you must learn to think like a lawyer, to anticipate the type of arguments you'll use, and learn how you can undermine them with ease. But in chess, as in law, trying to make preparations on the spur of the moment already means that you're too late. Thus, I'm going to walk you through how lawyers will attack your training tomorrow so that you can prepare your defense today. So I don't know how many chess players we have amongst us today, but we have a position here, white to move, and everything's equal. Everything seems quiet. Same material on both sides, and white has a wide array of moves at his disposal. If you take a moment to count, there are actually 26 possible moves for white. But, as it turns out, no matter what white does, on his next turn, it's going to be over. That's because I plan to move my rook from h4 down to h1, which would give check to the king, and all of the yellow squares are the squares that the king can normally go to, but he can't go to them because they're taken away by my green pieces. Now there is one square that's occupied by the rook, so if for argument's sake he tries moving the rook away, not going to matter. When I move my rook down to h1, it's going to be checkmate. The reason I show this is because it's too late to make your preparations 2 moves back, right? You have to start preparing from move 1 for the endgame. To begin your preparations, first we need to talk about why training is important and what happens if our personnel are inadequately trained or not trained at all. That's going to take us into our working definition of what constitutes legally defensible training, and we'll examine some important wrinkles in the area of Section 1983 lawsuits. Then we'll wrap it up with some ideas on how you can improve your own training and record keeping, and as I said, take any questions you might have. And before we go too far, let me go ahead and include my standard disclaimer here. Just because I'm going to teach you to think like a lawyer does not mean that you're going to lose your touch with humanity. It just doesn't happen that way. So, let's define the problem. Why do we care about training our first responders? Well, for the same reasons that most of us choose to go to a trained mechanic when our car needs repair, and for the same reason that few of us would entrust the education of our children to another individual who doesn't possess a teaching license. Training makes people more reliable in their professions and makes the end result safer. I mean, would any of you trust your heart surgery to anyone other than a licensed and trained heart surgeon? If you hesitated before answering, be sure to stick around after the Q&A because I'd love to help you on your next medical malpractice case. No, none of us would do that. We recognize the value of having licensed and trained professionals in these domains, yet history and case law suggest that law enforcement and corrections officers are sometimes entrusted with tremendous responsibility without an acceptable level of training. And contrasted to that example of heart surgery, poor training for law enforcement can not only endanger the public, but can place the untrained officer's life at risk, as well as everyone around them. It doesn't help that when budgets are cut, training is typically the first thing to go, even though this can have a disproportionately large impact on future budgets. But not all training is created equal. Training just for training's sake can be costly in many ways. Inadequate training can create a false sense of security or otherwise lead to serious injuries or death, And this can be for officers, for inmates, for members of the public, or all of the above. In a case from New York, for example, inadequate training policies were found to be directly responsible for an officer's death as he was shot trying to arrest a suspect. In other cases from Wyoming and Ohio, officers were forced to restrain highly combative individuals who were either under a high level of intoxicants or exhibiting high levels of psychosis, and after resisting restraint, the subject suddenly died in police custody. Multi-million-dollar lawsuits followed soon thereafter. In these cases, the government entities were held liable for inadequate training on how to respond to these individuals. These cases happen all over the country and at all levels of public safety. With all the allegations of police misconduct every year, it's not a question of if, but when it will happen to you or your department. And these lawsuits result in more than a proverbial slap on the wrist. In a Kansas case, a detainee brought an action alleging that jail officers used excessive force by using pressure point control tactics to subdue him before securing him in a restraint chair. A jury verdict returned $500,000 for his few moments of discomfort. These lawsuits come from both sides of the iron bars, by the way, with correctional officers and law enforcement officers also bringing suits for injuries that they sustained during or because of inadequate training. In a case from Louisiana, for example, a role-playing exercise in which trainees were encouraged to beat each other with a baton, not surprisingly, injured a correctional officer, resulting in a $1.8 million settlement. Of course, we can sit here and judge poor training with the benefit of hindsight all day. But the real trick is to identify problematic training before it begins. To do that, you need to ask yourself a few questions. Is that training preparing you for the job? Is it relevant? You can have great training taught by the best professionals that money can buy, and it may have no responsibilities or no relevance to your responsibilities. If I'm a correctional officer at a maximum security facility whose duties are limited strictly to the watchtower, taser training may not be meaningful to me. Next, will the training ensure that you go home at the end of a shift? Is it designed to make everyone safer? Simply asking this question may have saved that aforementioned Louisiana parish $1.8 million just by asking a question. Public safety is already dangerous. Training should help officers prepare for that danger, not unnecessarily expose them to more. And finally, the main topic of our discussion today, that deceptively narrow concept of whether your training is legally defensible. Why do we care whether training is legally defensible? Did you know that 1 in 5 officers will be accused of misconduct during their careers? In the last decade alone, the 10 largest cities in the United States paid out more than $1 billion in police misconduct cases. That's an average, for those of you doing math at home, of $10 million per city each year. Now, it may be tempting to underestimate the impact of these multi-million-dollar lawsuits, maybe because your department is smaller or because most municipalities and departments carry layers of insurance to protect themselves. But know this, insurance policies may not cover every cause of action, or they may not cover cases against officers in their individual rather than their official capacities. Everyone is exposed until they take measures not to be. So, what is legally defensible training? First and foremost, it must be of high quality. It must be relevant, and it must be taught by appropriate personnel. For example, being an excellent marksman and firearms instructor does not mean that you are automatically an expert on constitutional searches and seizures. More pertinent to our discussion today, though, are these 4th and 5th requirements. Essentially, you need to be able to prove that the training was of high quality, relevant, and taught by appropriate personnel. In the heat of testimony, could you quickly and confidently answer whether your firearm instructor certification was active when he or she delivered the training in question? Because of evidentiary concerns, the only reliable way to answer these questions is with thorough and accurate records. What needs to be in these records? Well, let's examine how the lawsuits start. I'm going to walk you through some statutes and legal doctrines, some of which have very precise terminology that you may or may not be familiar with. So if you have questions about the meaning of something I mentioned over the next few slides, I strongly encourage you to submit questions through the chat. I also need to throw in a disclaimer, a real one this time. Can we all agree that I am not your attorney? Before changing your policies or practices based on something I say, I strongly recommend that you talk to your attorney about the specific consequences in your jurisdiction, whatever they may be. There are many sources of law that plaintiffs' attorneys can rely upon to file claims against first responders. One of these is what's known as common law. Under the common law doctrine of respondeat superior, employers are responsible for the actions of their employees that are performed within the scope of their employment. However, because of various immunities, this doctrine does not apply to government agencies. Other types of state law tort claims may be available, such as false imprisonment or false arrest, assault, or battery, but there are various hurdles that attorneys face in trying to pursue them. For instance, in Indiana, the Tort Claim Notice Act provides that state agencies must be notified within 270 days of an act if you plan on suing them. For municipalities within the state, that period is shortened to 180 days. Moreover, due to tort reform over the years, most states have implemented statutory caps on the amount that can be won in a lawsuit against them. In Indiana, that amount is $700,000. In other states, it's even less. Thus, the majority of inadequate training lawsuits are brought not under common law or state law, but rather under federal statute, namely 42 U.S.C. Section 1983. Part of the appeal of Section 1983 is that there's no cap on damages. Immunity applies only to states and state agencies under very limited circumstances. There's no need to exhaust administrative remedies before bringing a suit. Winning entitles you to reasonable attorney's fees. That's an oxymoron, right, if you've ever heard one. And a lengthier statute of limitations. Instead of talking about 180 days or 270 days, the period can be up to 6 years that you can file a suit afterward. So let's examine what Section 1983 says. It starts with every person. While it might seem obvious what a person is, it's actually not so simple. Yes, a person can be a police officer, a deputy sheriff, a reserve officer with police powers, Department of Corrections officers, and other individuals. However, a person can also be counties, cities, branches of local government. It can also be a third-party organization, such as medical providers and a jail. Section 1983 also requires that an action be under color of law. The Supreme Court has stated that any act performed by a police officer in his capacity as a police officer, even if it's illegal or not authorized by state law, are acts that are taken under color of law. Thus, an off-duty officer can be acting under color of state law if they are attempting to enforce the law in any way. Thus, if you have officers that moonlight as security guards, they may be putting your department at risk for the actions they do at that job. An act can also be under color of law if the government delegates its responsibility to a private third party. Thus, actions at private correctional facilities can fall under the purview of Section 1983 as well. The rest of the language states that you can sue the government if your constitutional rights are impinged. Most often, this invokes due process concerns over life, liberty, or property through the 14th Amendment, but it can really be any constitutional provision. One Supreme Court opinion from this term actually involves a police officer suing his department for violating his free speech rights under the First Amendment by using Section 1983. However, even under Section 1983, governments do not become automatically liable for the acts of their employees performed in the scope of their employment. Instead, to recover, plaintiffs must be able to demonstrate that the act was the direct or likely result of an official policy or custom of a government entity. The Supreme Court has stated on several occasions that a single instance of misconduct is not, in and of itself, evidence of such a policy. The reason that lawyers care so much about training, and that it shows up in those tens of thousands of cases every year, is because the way that departments train their officers and record that training are policies that can be attacked under Section 1983. Thus, in both the discovery and trial phases of litigation, plaintiffs will try to demonstrate that your training was irrelevant, handled by an incompetent instructor, whose records, by the way, are also under scrutiny, or laid out a specific policy which led to the harm incurred by the plaintiff. leading to headlines like this one and the Freddie Gray trial that recently finished. But even if your training is of high quality, that's only the starting point of legal defensibility. As we mentioned before, you must be able to prove its quality in a courtroom. To do that, you must have detailed records of the training. Well, what if you have no records? If the records have been lost, misplaced, damaged, or otherwise destroyed, the doctrine of spoliation comes into play. You might want to jot that word down, spoliation. It has nothing to do with rotten or spilled milk, though it may be worth crying over if you're charged with it. Under the federal rules of civil procedure, everyone has a duty to preserve evidence which may reasonably be the subject of litigation. If that evidence is intentionally destroyed when an action is pending or imminent, the jury is going to be instructed to infer that the missing evidence would have been harmful to your case. Otherwise, you would have preserved it, right? That inference could be that an officer wasn't properly trained, that the department's policies were inadequate, or some other key assumption which essentially ends your ability to defend your lawsuit. But I think most of us understand that the destruction of evidence during a case, or even immediately before, is unethical. What about if a department just never preserves their records, or they're otherwise negligently destroyed? Well, then you're playing a game of proverbial Russian roulette with the district courts. Depending on the jurisdiction you're in, simple negligence is enough to permit a negative inference and end a case. In other words, gross negligence, in other jurisdictions, gross negligence or a higher standard may be required before such an instruction is given. That means that you keep paper records and they catch on fire or they aren't filed correctly. The consequences could be 6 or 7 figures large. And in the most serious instances, spoliation can also result in a court entering what's called a default judgment against you. That means you instantly lose. Thus, even if you have an otherwise ironclad case, a plaintiff may still win if you're not able to produce the records that he requests. Okay, well, let's say you have great training, and better yet, you have records of that training. What is the attorney's next attack? To stop those records from being admitted into evidence. To do that, first, he will use Federal Rule of Evidence 901. Under Rule 901, an item may not be admitted into evidence unless you can prove that it is what it purports to be. How do we lay a proper foundation to do that? Well, if a witness has personal knowledge of the training and the training record, then they can testify to that end. However, bear in mind that the statute of limitations for these claims can be as long as 6 years, not including the length of litigation itself, which can take several more years. The average tenure of a newly hired officer is somewhere around 3 years, so chances are slim that everyone's going to have personal knowledge of the training or the training records in question. As far as they know, the record could have been entered yesterday and they would be none the wiser. Thankfully, evidence can also be authenticated if you have a reliable process that you use to collect training records. Part of this is being able to show either a chain of custody or an audit trail so that there's no question about the integrity of your data. It's just like any other piece of evidence you maintain in your evidence rooms. But again, our battle does not end there. Attorneys are likely to object to the introduction of training records as hearsay. Well, what is hearsay? It is an out-of-court statement or record which is being offered in the courtroom to try to prove something. Hearsay is always inadmissible, except when it isn't. The Federal Rules of Evidence spell out several exceptions, the most relevant of which is Rule 803, Section 6, Records of Regularly Conducted Activity. If you regularly record your training records at or near the time of the underlying training event, it is no longer hearsay. I'll say that again. If you regularly record your training records at or near the time of the underlying training event, it is no longer hearsay. However, if you only record your training occasionally, or it takes you months to enter the data into your records management system, an attorney is going to make the argument that it should not be admitted. Again, if you can't offer evidence in your own favor, a judge or jury has little choice but to accept a plaintiff's version of events. Think about your day-to-day handling of records. For those of you wondering whether your current processes and systems meet the standards that we're talking about, know this: judges are human. And if there's any doubt whatsoever about the integrity of the data, some of them, not all of them, but some of them are going to rule against you. And if they do, reversing that decision on appeal is possible only if a substantial right is affected and your attorney makes a proper objection. Essentially, this means that a higher court is not going to admit the excluded evidence unless, first of all, it should have been admitted in the first place, and this is the real catch, the piece of information is so critical that it would have changed the outcome of the case. In isolation, it's hard to say that any singular piece of evidence meets that standard. Thus, our takeaways from evidentiary law are, number one, make sure that your training is applicable to the job duties. Number two, training must be taught by a qualified instructor, and records must be regularly recorded, they must be timely stored, and they must be securely maintained. So now that you know some of the issues, let's see how well we can spot them. Pennsylvania's Auditor General, Eugene D. Pascal, did an internal performance audit on the Pennsylvania DOC to determine if employees were adequately trained, whether work conditions were unsafe, and whether they were at risk for civil rights violations and costly lawsuits. This comprehensive assessment spanned from 2009 to 2012. It found that the state's Department of Corrections failed to monitor or review which employees were receiving training. The training was required by departmental policy and to satisfy American Correctional Association standards. Moreover, they did not complete the required training reports. Neither the DOC nor the training academies had automated systems to electronically monitor department-wide employee training. Their LMS was never fully functional, and it did not provide training reports or accurately record employee training. The Academy failed to monitor and review 945 employee training records at their central office, training academy, and community correction centers. In fact, only 5 of the 14 audited facilities met the required 90% employee completion rate. Some facilities had as low as 15 to 20% completion rates for training. The training academy staff failed to complete more than half the required training courses overall. So if you were an attorney representing, let's say, an inmate who was alleging negligent medical treatment by jail staff under Section 1983, how might you use this information? First, what are the consequences of failing to monitor and review employee training records? If training records are not reviewed, then personnel who lack necessary training or certification prerequisites could injure themselves or others on the job. Even though the DOC's official policy was to properly train employees, their actual failure to adhere to those standards is itself a policy for purposes of Section 1983. This puts the DOC at serious risk of litigation really anytime something goes wrong. Even though the audit was able to determine that only 5 of 14 facilities met training requirements, which is itself a problem, as a whole, the audit showed that training records were only occasionally maintained. By not regularly creating those records, the DOC runs serious risk that all of their training records are going to be excluded as hearsay anytime that they try to bring them up in a courtroom. Finally, jumping ahead, you can certainly maintain legally defensible records using only paper copies and filing cabinets, but why would you? Paper records are easily destroyed, they can be misplaced, they're harder to search and copy whenever you get subpoenaed, and they require manual processing at all stages, which is expensive. If you can't produce the records, remember that a plaintiff may allege spoliation. If you take too long to enter the data, the new records could be hearsay and also excluded from evidence. Despite these shortcomings, however, the Department of Corrections in Pennsylvania is light years ahead of some of its peers because at least they're taking a critical eye towards their processes and taking proactive steps to improve them. And as much as I want to tie everything back to litigation and to money, remember that at the end of the day, the most important thing is making sure that everyone goes home safely. But these two things don't have to be mutually exclusive, right? So that's it. You know what I know. So the only question is, what's your next move? Don't wait until it's too late to adjust your strategy. You have to start planning for the end game from move one, not when checkmate or the end is imminent, right? So on that note, I'll field any question you guys might have.
Well, thank you so much, Gerry. That was amazing. A lot of great information. We'd like to start answering some of the questions now from the audience at this point. So if any of you in the audience have questions, please remember you can type them into the chat window in the lower left of your screen. We got one question coming in here, Gerry. How can you prove that a record has not been tampered with or updated long after the event in question?
Well, I think that goes back to this concept of your training records must be treated as any other evidence that you hold in your evidence room. You need to have some sort of audit trail or chain of custody because, honestly, the person who handled the training record from its inception may not be the person who has to answer the question in the courtroom 5, 6 years later. The only way to prove that piece of evidence, that record is authentic, is to be able to trace it from the moment it was created. Otherwise, it really could have just been created the day before, and any plaintiff's attorney worth his salt is going to bring that up. He's going to say, how can you prove that you just didn't put this in yesterday to save yourselves? So you must treat it like any other piece of evidence. It is important to have that audit trail or chain of custody. And the truth is that most LMS is not meant to be legally defensible. They don't have that function to be able to track where it came from, when it was edited, who's seen it, who's had the ability to change it. And that's just the sad fact of some of the training records out there.
Thank you, Gerry. We have another question that just several actually are pouring in here. Are there any sites, blogs, or newsletters that highlight recent case decisions or suits related to this issue?
To this issue specifically, I don't know. There's, of course, legal updates courses that happen in every jurisdiction, and there's newsletters sent out by state entities, by private third parties that will update you on general case law updates. The trouble with getting legal updates on this specifically training records is what we mentioned before, that if you don't correct it at the trial stage, if you're not ready for trial, chances are you're not going to get an appellate decision that reverses anything and talks deeply about these issues of training records. So at the trial stage, it's incredibly important, but at the trial stage, you don't get these lengthy opinions. You don't get things that you can share with people. You don't get these sort of great materials you can hand out. So even though it's not showing up in your legal updates, it doesn't mean that it's not happening. It's just really emphasizing how important it is to have everything ready at trial stage, because you don't get that second chance to show the defensibility of your records.
Thank you, Gerry. Another question came in. Is there a training record recorder that you recommend, or a training management system?
Well, I won't get too deep into that question. I will say that a Cadis is developed with all of these things in mind, but it's just important that it keep all of these things in. We talked about them being regularly recorded. You have to have this audit trail. So these are the things you need to be looking out for. These are the differentiators that you need to be going to market with, asking LMS providers, hey, are you going to actually give us legally defensible records, or when court comes around, are you just going to hang us high and dry? So I think I'll leave it there.
Thank you, Gerry. Another question came in. How long should training records be maintained past the separation date of an employee from service?
That is actually a great question. It must be at least as long as the statute of limitations, right? So if we release an employee today, remember that depending on what jurisdiction you're in, a case can come as much as 6 years later, right? So even though you might not have any reason to suspect that your employee has done anything wrong, let's say they did something the day before they got fired, it could be 6 years minus a day later that the lawsuit is filed, and you need to have those records ready. Otherwise, as we mentioned, you're going to have to deal with issues of spoliation. You're going to have trouble getting your evidence admitted. So at least make sure that your meeting that statute of limitations. Otherwise, it's going to be hard to defend yourself.
Thank you, Gerry. Another one, are you aware of any litigation that attacks the underlying training standards established by the governing body responsible for promulgating those standards?
Could you repeat the question?
Yes. Are you aware of any litigation that attacks the underlying training standards established by the governing body responsible for promulgating those standards? So, for example, POST. I think what is being asked here is there any lawsuit that actually attacks the standards that were set by, for example, a state post?
Well, there certainly can be. Are we talking just about training records or just any state post standards at all?
I think it's essentially the question is really related to litigation against the standard setting body.
Right. I think any state post you ask will answer that yes, they're seeing litigation. Their policies are being challenged. Whether or not successfully is another question. But it helps to have the policies, right? Just because your policies are going to be challenged by plaintiff's attorneys does not mean that it's not worthwhile to implement your policies. You need to make sure that your policies are meeting standards that are high enough in comparison with other jurisdictions, right? As we mentioned, a lot of these lawsuits are coming as Section 1983 lawsuits in federal courts. And remember that courts of appeals for federal courts cover several states. And so if your state has the absolute lowest standard for something out of all of the surrounding states, courts are going to look at that in determining whether or not something is a reasonable way to deal with things.
Thank you, Gerry. Another question, very interesting, for a perishable skill, such as combatives or emergency vehicle operations, what problems do you see with some persons taking a class about the subject with no hands-on demonstration versus someone who has to demonstrate the skill and receive classroom-style training?
Well, I think that's absolutely critical. We talked about relevance, right? I think for all of these perishable skills that involve or should involve actual physical demonstrations of skill, you lose that ability to demonstrate relevance when you say that you're only doing a classroom component of it and that you're not doing the real-life component. I could take all of the online courses about firearms that there are in the world, but that's not going to help me in high-pressure situations in ascertaining whether or not somebody should be shot or if I should do some other course of action. So absolutely, when you have these perishable skills, you need to be able to demonstrate that you're not just handling one, but you're handling both components of it.
That's really interesting, Gerry. I guess that's the difference between knowledge and skills training, right? Knowledge skills are two different. One's a psychomotor skill and the other one is something you know. And that's Absolutely. A really interesting distinction to be made there. What entity would you recommend that would have sufficient knowledge of training requirements and tracking? What entity would you recommend for an audit similar to the Pennsylvania DOC example?
Oh, goodness. I know theirs was internal, but as we mentioned, that took a long time. That occurred over 3 years. And to be quite honest, not everybody has the resources and the time to dedicate to their internal audits those kind of resources. I think the key is if you're not able to do these assessments quickly by running reports on whatever software or whatever records keeping system that you have, something's probably not happening the way that it should be. It is possible to have a records management system that will tell you immediately whether you are in compliance with all of the things you need to be in compliance with. And if you can't answer that question very quickly, honestly, it's only a matter of time before a subpoena comes in and forces you to answer that question. So you need to be ready ahead of time, not when that subpoena actually does come in. So yeah, if you're asking yourself that question, I would take a serious, long think about whether your current system is meeting your needs.
Thank you, Gerry. What are your recommendations then in terms of how long to hang on to certain records? Aside from electronic records, how long do you hold on to actual paper, tests, evaluations, et cetera, that might underlie the digital record?
So I think there's two important points here. First of them is, do we need to keep paper copies of things? And for the most part, the Federal Rules of Evidence, I think it's Rule 1003 or 1004, talks about copies of things, keeping digital copies of things, duplicates of things. And for the most part, you don't have to keep originals of things. The only time you will need an original is if there's some genuine question raised about the original's authenticity, or sorry, the duplicate's authenticity. So if I go into a courtroom and it looks like something has been tampered with, yeah, then at that point I might need to be able to demonstrate what the original actually said. But for the most part, there is no magical quality about paper records that you don't get by having digital records. The second part of it is, how long do I need to keep records? And that's where I have to go back into that disclaimer that, yeah, I'm not your attorney, so don't take this for at face value, but it's really going to vary by jurisdiction, right? Everybody has different policies about record retention, so it might be a couple years here, a couple years there. The important thing, though, even though I can't give you a specific breakdown on how many years, because that's going to depend on law and regulation, is make sure you have some sort of policy, right? You don't want to just be hanging out there keeping records indefinitely. That's costly and unnecessary. And when you have a formal policy and you destroy records in accordance with that policy, and it's reasonable and in accordance with all the laws and regulations, then you don't get in trouble when you destroy those documents in accordance with that policy. So if I have an officer's training record and 10 years has gone by and we have a policy that says after 10 years we're getting rid of it, then in no instance is the court going to say that there's spoliation because I got rid of that record. As long as I'm following my policy, it's reasonable, it follows all the law.
Thank you, Gerry. What is considered a reasonable amount of time between completion of a training session and entry into a database or training record?
Yes, that is an absolutely great question. The word reasonable shows up in all instances of the law. And the fact is that whenever you see the word reasonable, it's just going to be whatever a reasonable person would do. And that often comes down to a jury question, right? And so remember, it's sort of like the example I was talking about with the judge. If there's any doubt about whether something is in compliance with the law, when you have reasonable people may differ, right? And so if there's any question at all, sometimes you're going to people saying, yes, it's compliant. Other times people are going to say, no, it's not compliant. And so that's really where the problem lies. You can't leave any question to it. You have to make sure that you're in compliance with all of the requirements.
Thank you, Gerry. Scroll up. I've got one more here. Do you have any federal quote-unquote horror stories concerning training records maintenance? Often these types of examples get people's attention.
Ari, you may be a better answer of that. You have so much experience.
Actually, I do have one. This was a little while ago. We were consulting for a federal law enforcement agency. I will not name the agency. And they revealed to me that they had lost 6 years' worth of basic agent training. In other words, and these are active agents out in the field. They cannot substantiate that these agents who are currently active carrying firearms and prosecuting their duties out in the world were trained, had their basic CITP training at FLETC.
And see, that could really undermine every single bit of training that you have. Just in the example of people have had problems with DUI training. Perhaps the software had a malfunction, and people who had been otherwise certified for DWI training, it wasn't actually clear whether they had gone through the training as it was intended to be gone through. And because of that glitch in this LMS course, all of a sudden, hundreds and hundreds of DWI cases are now all of a sudden going to be undermined or possibly settlements entered into simply because it's going to be harder to prove that they were authorized and certified to do what they should have been doing at the time of the incident. And so it really only takes one record to be destroyed for the entire system to come crumbling down on you. So that's incredible.
Another great question here, Gerry. If a person keeps personal copies of his or her training records, can this meet the requirements of 901 and 803?
In order to protect themselves, I assume is what we're saying. So let's say you don't trust your department's record-keeping policies, or you just want to make sure that you have your shoebox at home filled with all the requirements. Yes, because oftentimes when you get those paper diplomas, they are created at or near the time of the underlying training incident. But of course, you always have those questions about authenticity, right? It's hard to prove a chain of custody or an audit trail on your paper diploma. I mean, you could just as easily draw something up in Word or any Adobe program. So again, a plaintiff's attorney is going to bring up, is this actually authentic? And so you're going to have to really work to establish a foundation. But those aren't meaningless, right? I would say if I was an officer, then that was absolutely something I would do as an additional measure to protect myself, just because sometimes authenticity does come into question.
Thank you, Gerry. Another really interesting question here from the audience. How important is it to demonstrate and record proficiency of training as opposed to just an occurrence of training? In other words, that the trainee understood and is capable of carrying out the task after the training was conducted.
That is absolutely critical to legal defensibility. And I know we didn't touch on it, or at least not as much as I should have. But just to show you, a lot of training isn't legally defensible for precisely that reason. Lawyers, for example, in those states, I know Indiana is one of them, continuing legal education is not legally defensible in the sense that law enforcement training needs to be. And that is because if I go to a continuing legal education course, I can actually fall asleep. All I have to do is be in the room for the hour or 2 hours or 6 hours of credit. And if I am in the room, I can say that I am there and I've got my training. Can you imagine that sort of thing passing in the law enforcement context with millions of dollars on the line? Absolutely not, right? So most training out there is not made to be legally defensible. And so that's why you really have to work to make sure that your policies and the content that you're getting are meeting those standards. But it's really quite incredible how many professions out there don't touch on this as much as they should. And for some of them, they get away with it just because they don't get sued under Section 1983, or there's tort reform preventing them from having these large lawsuits against them. But yeah, you absolutely have to make sure you're looking out for that.
Thank you, Gerry. What guidelines, another question here, what guidelines are followed to certify or qualify an instructor when no train-the-trainer course exists?
Yeah, different states are going to have different requirements on what instructors need to have done to meet certification requirements. And maybe the question is, if the state doesn't have any requirements, what are we supposed to do? Even if there's no train-the-trainer course, you need to somehow be able to demonstrate that the trainer knew what they were doing, right? I can't go into a state and just start teaching firearms courses, right? That wouldn't teach anybody anything. I don't know anything about firearms. I'm not going to be helping anybody. It's not going to be relevant. It's going to make things more dangerous. It's the least legally defensible thing that there is. So it's not just about proving that, yes, I passed the course. Yes, I got great scores on all of my practical portions. I need to be able to show in some way that the instructor knew what they were doing. Now, if my state doesn't have some sort of formal certification requirements for the trainer, or there's no train-the-trainer course available, then I have to actively go out and seek people who are known experts in the field, or who already have these certifications that my officers are trying to get. But you have to be able to demonstrate it somehow. You can't just throw anybody in there and expect it to fly when a lawyer is cross-examining you.
Makes a lot of sense, Gerry. Thank you. Another question here, I think it's referring to one of your slides and one of your examples. Does that governing state agency enjoy immunity protections under federal law that would affect those suits currently under discussion?
So there are various state-level immunities, right? For example, state police agencies often cannot be sued under federal law, and that's constitutional. So immunity comes into it, but that's the great thing about Section 1983 is that most immunities don't apply under Section 1983. That's why plaintiff's attorneys really love it, is because a lot of the state law things, because most states don't want to be sued under their own laws, they have to affirmatively opt into it somehow. Under Section 1983, a lot of these immunities don't apply. So I would never depend on an immunity to cover you for poor training records or for poor training, for that matter. You, of course, want to talk to any sort of attorney that you have in-house or that you can consult with. But no, I would never depend on an immunity in the Section 1983 concept. So, yeah.
Thank you, Gerry. All right, that's. I think we've covered most of the questions here. If we didn't cover you, we're sorry they were streaming in so fast. We've tried to keep up with all of you. But that's all the time we have today. I'd like to thank Gerry for providing his perspective and sharing his experience with all of us. Gerry, it's fascinating and certainly troubling and scary to know all the different chess moves that attorneys can make when they are bringing suit. I'd also like to thank all of you for attending. This is a really, really important topic because to the extent that we start to think deeper about legal defensibility, we're also going to start to think more deeply about the quality and the relevance of the training that we're providing to those folks on the front line. And for us, all of us at Envisage here, ensuring that people are adequately trained as well as they possibly can be means that they come home alive, they come home safe. And that's very, very important to us. We have recorded this webinar. We will be sending this out in the coming days so that each of you, I hope you can share that with other interested parties within your departments or even colleagues that might have an interest in this information. In addition, you will receive a survey after the event. Please fill it out. We are constantly trying to improve this webinar series, and your feedback is very helpful to us in also understanding what topics might be of relevance for you. We find speakers from all over the country and we bring them on to have these talks with you. So please take a few moments to fill it out. That's it for this webinar. We hope to see you all in future webinars, and we wish you all a wonderful week.